Yes.
Please, Your Lordship, I beg to mention item number 9, Your Lordship.
Item 9.
Yes.
Yes.
My Lord, on the last occasion, the learned PP had apprised the court that this case diary will be available on 25th of this month.
We'll fix on 25th.
Yes, Your Lord.
Probably this was
Wrongly listed.
probably due to the direction from the Supreme Court listed, huh? So the Miss
D. Tamuk, Your Lord.
Planning Council for the you are for respondent
Yes, Your Lordship, for the victim
or
complainant.
for a victim. Okay. The record reveals that the matter has already been fixed on 25th
Yes, Your Lordship.
of
Yes,
March.
March.
Okay. As the matter is directed to be listed on 25th, let the matter be listed on the said date. Okay. On 25th. Okay.
Much obliged, Your Lord.
Hmm.
I'm trying to looking up one film on Monday. Connected with the
Okay.
Item number 1.
May I please, my lord? My lord, this criminal revision is filing in connection to the impugn order dated 15/1/2026, passed by the special learned special judge at UPIA. In connection to POCSO case number 26/25 in Itanagar CS case number 63/25. Before I made the brief fact of the case, Lordship, I take to in the impugn order, my lord. Page number 17, my lord.
Page 17.
Yes, my lord. Page number 17. May I read on, my lord?
This is impugn order.
Yes, my lord. Page number 17, annexure 1. Today, the present case is fixed for production of the accused person and hearing on charge. Accused person, namely, Bingya Thakur, produced from judicial custody. Learned counsel for the accused, Mr. M. Martin, assisted by learned counsel, Mr. Tam Lamdak, have been appeared for the accused person. The state is represented by learned special PP, Mrs. K. Bagra. It is submitted to learned special PP on completion of the investigation. The IO of the case has submitted charge sheet against the accused Bingya Thakur for commission of an offence under section 108 of BNS, read with section 6 of POCSO Act. It is clearly submitted by learned special PP that even though the father and mother of the deceased have
Since Mr. Edgar, you have made party also. Okay.
yes, my lord, I made party to the
And
accused.
it's-
Division 1 and 2.
Accepted notice on behalf of the state respondent. No formal notice need be issued. The petitioner, however, the petitioner shall take steps upon the private respondent number 2 by a speed post with AD as well as by usual process within 3 days from today.
My lord,
Within a week
within a week.
from today. Start at least this matter
4 weeks, 3 weeks, man.
after 3 weeks. Okay.
Much.
Item number 2.
My lord, this application, my lord, is under section 482 CRPC, or we can corresponding provision is 428 of BNSS. My lord, a murder trial is going on. Am I audible, my lord?
Yes, yes.
A murder trial is going on, my lord, and I am the accused in the murder trial. The incident happened on 23rd of April, 2023, my lord. 2024, my lord. Now, most of the evidences were recorded when I was in judicial custody, my lord. More particularly, witness number PW1 to 6. When I came out, when I was released on bail, my lord, on 5th of May 2025, in the meanwhile, at least 12 witnesses had been recorded, but I am seeking recall of PW1 to 6. The reason being, my lord, if you look at the cross-examination, my lord, you will find that there is hardly any cross-examination. And this happened not because of the fact, my lord, that there was no proper instruction between the counsel and the accused, since the accused was in judicial custody. So, my lord, if you look at the cross-examination, my lord, it starts at page, my lord, 101. Annexure 4, my lord, page 101. Now kindly see, my lord, 101 page, it is the evidence of PW1 and he is the informant, my lord. Now his evidence has been recorded, at least it is more than 3 pages, my lord. Now kindly come to page 103. At the bottom, your lordship will find the cross-examination, which continues on the next page and it ends there. Now what has happened,
Yes.
my lord, most of the pertinent questions that ought to have been put could not be put because of lack of communication between the counsel who was dealing with the matter and the accused, since the accused was in custody, my lord. Now kindly go to the next page, my lord, page 105, PW2.
Yes.
It is more than one and a half page, my lord. The cross-examination is hardly 4 lines. Now kindly proceed to the next. Same has happened, my lord. And same is the case with between evidences of 1 to 6. Now what happened thereafter, my lord? When I was released on bail, I approached the counsel and I gave him the full instruction as to what had happened on that day. Thereafter, the learned counsel who was dealing with my matter, he contacted a senior counsel. Thereafter, both sat together and they decided that an application should be filed for recalling of witnesses, particularly witness number PW1 to 6. And your lordship will find that an application which is Annexure 11, page 121, was filed. Page 121, my lord, Annexure 11.
Yes.
This application was filed on 10th of October 2025, my lord. In the meanwhile, 12 witnesses had been, evidences had been recorded. In this application, my lord, we have specifically stated that because of the communication gap, there was no proper instruction and therefore there was no proper and thorough cross-examination which ought to have been done. In the absence of proper cross-examination,
The counsel was engaged counsel only.
my lord.
The counsel, defense counsel was engaged
Defense
counsel only.
counsel was engaged only,
Yeah.
my lord. Now, kindly see, my lord, that for example, my lord, if you come to para 6 of the application, the incident, my lord, just a little backdrop. The incident had happened at 7:30 in a school. Naturally, at 7:30 in the evening, my lord, the school was closed and there was none. Now, the question could have been as to what was the light, since the darkness had fallen, what was the light that was available in the school campus when nobody was there? What kind of atmosphere was there, whether it was raining, it was a day where there was no
So
rain.
you want
my
to
lord.
improve,
My
so you
lord,
want to improve your case?
No, my lord, I'm not trying to improve, but I need to have full justice, my lord. Now, what has happened, my lord, I am not for this application. This application is still pending. There is no decision. But unfortunate part is that the learned sessions judge, he is proceeding with the trial. This application needs to be disposed of. Kindly come to the subsequent page, my lord, page 128. On 2nd of December, my lord. This
Yes.
application was page 128, my lord.
Yes.
2nd of December, the learned sessions judge for the first time considered this application. This was placed before him. He looked into it and thereafter he thought that the prosecution should be given an opportunity to submit their objection, which is quite natural, my lord. Kindly look at paragraph 2. Senior advocate so-and-so, assisted by learned counsel Mr. R.K. Pandey, appeared for the applicant accused. Learned counsel shall serve the copy of application to the learned PP, Ms. D. Yoka, during the course of the day. Heard submissions made by learned senior counsel. Fix 22/1/26 for hearing on the petition filed under section 311. Now on 22, my lord, my sister-in-law, 5 days ahead, she died. And I was performing some rituals, my lord, which is applicable for every Hindu. Now kindly come to the next page, Annexure 12, my lord. Unfortunate part is that Advocate Neelam Tae, his own brother, he also died on 21st of January. We both were absent on that day, on 22nd of January. And on our behalf, an application was moved, giving the reasons that why I am absent, because I was performing some rituals because of death of my sister-in-law. And Advocate Neelam Tae, he also could not remain present because of death of one of his brothers, my lord. This application was taken into consideration, but learned trial court did not grant any adjournment, and on that day another witness was recorded and an amicus was appointed. Now, where a counsel who is a defense counsel engaged, my lord, if he fails to put pertinent questions in the absence of proper instruction issued by the accused, my lord, what kind of
This is with regards
defense-
to all, this is with regards to only one witness, doctor.
That is doctor, my lord, but we are on the application that my application 311 should be considered first before further proceeding with the trial, my lord. And the trial court is to consider the reasoning that we have given so far, recalling of witness number 1 to 6 is concerned. That is one part. Another part which has come to our notice at the time of preparation of this application, my lord, is that one Kulwant Singh, who is PW9, he has spoken about many things. Kindly see, my lord, page number 116, my lord. Kulwant Singh.
Yes.
Kulwant Singh, my lord, he is one police official, but he has not spoken in his official capacity. He has spoken as to what he had seen on that day in regard to seizure of weapons, a weapon of murder, my lord, and in regard to seizure of clothes and other items. When we look into his evidence, my lord, next page 117, your lordship will find at the bottom P Exhibit 10, containing 3 images pertaining to the recovery of weapon of offense, blood-stained shirt, accused recovered from septic tank, and blood-stained trouser of his son recovered from the house of accused, which I have identified. These photographs in color were never provided to us, my lord. So section 207 of CRPC clearly...
You have cross-examined on that day itself.
My lord, but I should be supplied. I was taken aback. Kindly come to the same page, my lord.
Where have you stated in your cross-examination?
My lord, but I have a statutory right to have all the documents. I cannot be taken by surprise. So for photographs and pen drive is concerned, my lord, I am not on any statement.
Where have you suggested that you have not been shown this paper or not given?
Subsequently, I made an application, my lord, and thereafter on 22nd of January, I have been provided with the certified copy of the photographs and the pen drive, my lord. Under section 207
Yes,
of
what?
Yes, my lord, before going into the, my lord, the merit of the case, my lord, I would like to take your lordship to the provision of 442, the revision provision, my lord.
Yes.
Because, my lord, they have not implicated the victim in this case. First of all, my lord.
How many? Okay, only state.
Yes, my lord, only state has been implicated, but it's a criminal revision petition, my lord, wherein your lordship filed in the 442, the High Court power for revision, in subsection 2, it's clearly reflected that no order under this section shall be made to the prejudice to the accused or other person unless he had an opportunity of being heard either personally or by advocate in his own defense. So other person comes the victim. My lord is very aware the victim participatory right. And the revision is mandatory, my lord. And second part is, my lord is well aware, the 311 is not for fill up the lacuna or improvement, my lord.
Yes.
In that case, if there was no any opportunity or the document has been supplied, they could have declined and immediately approached the court.
Right.
That has not done. Now, after examining everything, now they realize that these things ought to have been done. That is not the, my lord, purpose of 311. 311 is for the just decision, my lord. And it is the discretion of the learned special court or the trial court to decide for fair decision whether the recalling of the witnesses are required or not, my lord. And now in this, my lord, present application, this is indeed, it's an incomplete because there is no any impugn order as such, my lord. There is no any impugn order, my lord.
Hmm.
They file an application, they're saying that they file an application on so and so that. But my lord, when it comes to revision,
Hmm.
my lord is wherever the limitation also count, my lord.
Mhm.
For limitation, there must be an impugn order. They must be impugned by some order of the learned special court, my lord.
My
They
lord,
only
may I
annex the
add-
application, my lord.
You implead the victim.
I will do, my lord, but before that, may I make
Okay.
a distinction, my lord? May I make a distinction? This is not a revision. This is under section 482 inherent power of the Honorable High Court. My brother is right when he is saying that there is no impugned order because my application is still pending, my lord. So there is, but I am only trying to show, my lord, the haste in which my trial is being conducted. When an application is pending and when there were two deaths in the residences of the respective councils, what was the urgency, my lord, on 22nd of January, at least to record the evidence? The hastiness, my lord, is bothering us. So this is not a revision, my lord. Still, we are ready to implead, my lord. But my humble
My lord,
submission will be, we are ready.
My lord, may kindly come to the prayer part, my lord. Kindly, my lord. Actually, this is not at all maintainable then, my lord. They have invoked 482 CRPC. It's already gone, my lord. It's not operating, my lord, the 482 CRPC.
I will explain that, why it is operating. My brother,
My lord,
may I?
The corresponding 428.
a revision petition under section 482 CRPC 1973 corresponding to section 428 of, my lord, the corresponding section 428 is judgment of subordinate appellate court, my lord, of BNSS 2023, praying for issuance of direction. These sections, and my lord, with due respect to the learned senior counsel, my lord, this aspect has been settled by our division bench, my lord. When the application is filed before the High Court, after coming into force of the new Sanghita, even if the matter is pending under CRPC, the application has to be prepared under the BNSS, my lord.
Yes.
That is well settled by our High Court, my lord. Even if it is pending, my lord.
Prayer.
So far wrong typing is concerned, my lord, I will correct that. But may I make the distinction,
Yeah,
my
your
lord?
your application under 311 CRPC also, then in that should have been under BNSS.
My lord, this debate is still going on as to what should be the natural course of action. May I take your lordship to 531 of BNSS? 531. And therefore, my lord, to be on the safer side, we have quoted both these sections. I would like to read out section 531, repeal and savings, my lord,
No, that is fine only.
of BNSS, my lord.
Yes.
The Code of Criminal Procedure 1973 is hereby repealed. 2. Notwithstanding such repeal, if immediately before the date on which this Sanhita comes into force, there is an appeal, application, trial, enquiry, or investigation pending, then such appeal, application, trial, enquiry, or investigation shall be disposed of, continued, held, or made, as the case may be, in accordance with the provisions of CRPC, as in force immediately before such commencement, as if Sanhita had not come into force. Now, my lord,
That is
my
true. That is true.
investigation on 1st of July,
That
my
is true,
lord,
but
when-
your application
Your
application was filed subsequently after the
my lord,
after the Sanita only. Sanita
My
came
lord.
into
yes,
force.
my lord, perhaps the senior counsel is not aware of the judgment rendered by the
Division
division bench in
Then I am
2024.
aware, my dear brother.
GLT 756, my lord, wherein in read, my lord, the suo motu has been taken by the,
Okay. Anyway, so what do we do?
they have to
So,
correct it, my lord.
My lord, I
you
will
need to
correct it.
it
I will
appears.
correct it and I will implead the informant since that objection has been
Correct.
raised. But in the meanwhile, my lord,
Which one you will correct?
it will be
Which one you
BNS,
will correct?
the front page, my lord, the title page. Because along with the CRPC provision, my lord, we have also spoken about the provision of BNSS as an abundant caution, my lord.
Where was your application under 311 before the trial court page?
It is page, my lord. 121, my lord, 121.
So this was also made after the application of BNSS, and then you have made an application under 311 CRPC, not under BNSS.
Yes, my lord, I will only read out the operating portion of the judgment of our High Court, my lord.
Yes.
In view of the discussion made herein above, the referred question is answered as follows. Any pre-arrest or regular bail or criminal petition filed after 1/7/2024 in connection with an FIR registered prior to 1/7/2024, that is before coming to force of the BNSS 2023, are liable to be filed under the provision of 482, 483, 528 of the BNSS 2023 respectively, my lord. So it has to be filed under BNSS, my lord.
Yes.
I
And
will
my
do
lord,
that.
and the provision which
Okay.
mentioned in the petition is, my lord, that is a revision petition under section 482, my lord. Revision cannot be filed under 482, my lord. If we take this 482 is a correct provision. And secondly, my lord, the corresponding section of the BNSS, the written is 428, my lord. The 428 is judgment of subordinate appellate court, my lord.
Okay, different.
Different, my lord. The corresponding section would be, my lord, 442, my lord. 442 of the BNSS, it says High Court power of revision, my lord.
I think, Lion Senior Counsel, I think you may have to change the entire petition. Then in that
I
case.
will do that, my lord. So what
So
I
then
do,
in that case,
my lord, what I do, my lord, kindly give me the liberty so that I approach the trial court. There itself, I file a fresh application on the next date itself. And I will withdraw this application because that application is still pending, my lord. That is yet to be decided. So I will file a fresh application under the BNSS provision. Otherwise, also that right is available,
Okay.
my lord.
okay. Mr.
SK Singh, my lord.
S.K. Singh, Lion Senior Counsel, assisted by Mr. N. Taji, Lion Counsel for the petitioner. Submits that he may be allowed to withdraw this criminal revision petition with liberty to make appropriate application before the trial court. The prayer is allowed. This criminal revision petition is dismissed on withdrawal with liberty as prayed for. Okay.
Obliged, man.
My lord, can there be an observation that when I make the application, at least that will be considered for side by side if the trial
Liberty is given
continues,
to
my
you.
lord?
Liberty is granted to you. That is enough. I
Obliged.
think. That should be.
Obliged. Deeply obliged.
Matter number 3,
Yes.
But this anticipatory bail arises from a profound personal tragedy where the applicant, my lord, despite her bona fide efforts to amicably resolve a complicated relationship, my lord, now find herself entangled in an unsubstantiated accusation of abatement that lacks the essential legal ingredients of intent and instigation. So, my lord, having said so, my lord, having submitted so, my lord, I'll come to the FIR, my lord. There is one boy, my lord, who was having affairs with another girl, and then the applicant, the boy also get in relationship with the applicant. So later on, what had happened? This was discovered, my lord. This was discovered, my lord. And they are staying in Delhi for the UPSC coaching and APCS and all those things. So there was a Zoom call, my lord. So she, in her bona fide, my lord, she tried her best to, having detected that his boyfriend is already having a girlfriend. So she wanted to clarify everything. And to clarify everything, my lord, she made a Zoom call. And everything was cleared, my lord. So on that fateful day, what had happened was, two voice calls were there, not video call, my lord. it was recorded by everybody. And then what had happened, the applicant said, I'm sorry, sister, that your boyfriend is already having a relationship with you. Now I have also been, brought into here. So now I'm parting ways and you live happily, Mila. So because of that, what had happened, this FIR was lost and subsequently it was registered under 108 BNSS and section 3, subsection 5 of the BNSS. That is not general section now, the common intention, Mila. So now, Mila, kindly see, I have narrated the entire FIR in the, extracted the entire FIR in paragraph 3, Mila. Kindly come. It's a better, Mila, if we go through the complaint first, Mila. Page 20, Mila.
Yes.
If, my lord, it is clear, then I can proceed with, otherwise the
Just a
time
minute.
bomb
No.
is clear, my lord.
Hmm.
Okay, let's read together. So and so, I so and so, as about so and so, the resident of so and presently residing in A sector, Itadaga hereby submit this complaint for registration of FIR regarding the so and so of my sister, Miss so and so, 29 years, daughter of so and so, presently was residing at Thorns Comfort Home Stay near Tuesday Market, Gopur, Itadaga. Around 5:51 p.m. on 14 March 2016, I received a call from so-and-so informing me that my sister so-and-so has locked herself inside her room at my building, Tuan's Comfort Home. Sorry, madam. Stay near Tuesday Market, Gopur. And then I immediately rushed to the spot and found my sister hanging from ceiling and found her that after informing the incident to all my relatives, we had decided to take her body to the blaze for the last rituals. But later I came to know that my deceased sister has forwarded her mobile phone password to her sister so-and-so. And having unlocked her phone, I found a video clip which was sent to her boyfriend so-and-so, stating the reasons of her suicide as so-and-so and so-and-so. It is submitted that Sri so-and-so has in relation with my sister for years. Even the family members of had approached and acknowledged their relationship to me just few months back, and thus so-and-so relations were acknowledged by the family members. Now, of late, it was found that so-and-so has another girlfriend, Miller. Here I comes in, Miller, with whom he was harassing my sister through WhatsApp group calls. As per records on 11 March 2026 at 12:07 p.m., Miss so-and-so initiated a group video call and they had 28 minutes, 60 seconds hot argument. And again on so-and-so, on so-and-so, these are the date, Miller. I'll group called so-and-so. I read from the last night. It is found that for her past few years, the disease had been under severe mental stress and harassment caused by so-and-so, 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 one so-and-so, and three so-and-so. Due to continuous harassment and inducement by accused, the disease become mentally disturbed and ultimately took extreme step of committing suicide. But I can understand these days the young boys and girls, they used to have multiple relationships. And because of that, sometimes they become psychopath. And these kind of things, and this has led to this unfortunate situation. Now, accordingly, the police have registered the FIR. But for the sake of see my clarifications, that I have directed how things I have initiated to resolve this matter. The brief fact of summary, para 5, page 5, it starts. How I came to the life of so-and-so, the main accused in Delhi.
Just a minute. You are
I am Badak.
the.
Badak. I'll not.
Yes,
I am not taking the names of
yes.
accused and
that's-
for the reasons there are judgments. Well, this particular thing,
Para 5.
para 5, my lord. This is how I come up with the clarifications.
Hmm.
Well, that in the year 2020, the applicant came to know Sri so-and-so in Delhi while pursuing coaching for the UPSC so-and-so through her brother, Sri so-and-so, all three of whom were enrolled at the same coaching institute, namely ALS, Delhi. However, due to the COVID pandemic 19, all of them returned to their respective homes in Itanagar and lost regular contact. Initially, the applicant and Sri so-and-so developed a cordial friendship, which over the time gradually evolved into a closer personal bond. Subsequently, around December 2022, Sri so-and-so expressed his feeling for the applicant and proposed entering into a relationship with her. The applicant accepted this proposal in good faith, entirely unaware that he was already in a relationship with another person, Miller. So this is my bona fide, Miller, because I was misinformed that upon entering into a relationship with so-and-so, the applicant came to learn that the deceased was also in a relationship with him. As soon as this fact came to her knowledge, the applicant in a bona fide and transparent manner reached out to the deceased to ascertain the true nature of the situation. Thereafter, discussions and communications took place among all three parties, with each seeking clarification of their respective position. Despite several conversations, no amicable or conclusive resolution could be reached, as all three were simultaneously engaged in preparing for the so-and-so 2024 examinations, were keen to avoid distractions. They mutually agreed to keep the matter in abeyance until the completion of the examinations. That after completion of the said examination, the applicant decided to resolve the matter permanently and amicably by distancing herself from the relationship and severing all ties, as he had also been experiencing considerable emotional distress. Accordingly, around the first week of February 2026, the applicant and so mutually decided to end their relations and cease contact with each other prior to their final separation. Both agreed to hold a joint conference call up with the deceased to conclusively and amicably resolve all pending issues, though the exact time and date for such a call had not yet been fixed. Having reached this understanding, they parted ways. I am already separated. On so-and-so March 7 months to Delhi to resume her. I'm there in Delhi, madam. Close.
When the incident took place, at that time,
40.
you were?
The call was from Delhi, madam.
Okay.
On 7th March, I was in Delhi, madam. Onwards, 96/7, madam. Page 7, this Roman formula.
Yeah.
That on 7 March 2026, the applicant returned to Delhi to resume her preparation and professional pursuit. Since then, she has been residing in a paying guest PG accommodation in Delhi, concentrating on her studies and career and maintaining complete distance from any personal dispute or interactions that could interfere with her preparations. That on 11 March, on 11 March 2026, after a considerable gap and in pursuance of the earlier understanding, the applicant initiated a WhatsApp audio conference call with deceased and Sri so-and-so with the specific purpose of conveying that the relationship had come to an end and ensuring that the deceased was duly informed of this decision, Miller. The intention was good, Miller. Intention was good. The deceased responded positively to this communication, appreciating the applicant's honesty and transparency and expressing her gratitude. Thereafter, the applicant completely ceased all personal contact with so-and-so and deliberately maintained distance from him so as to focus entirely on her studies and career and to avoid any further personal or emotional involvement. The incident here, Roman 6. That on 14th March 2026, so-and-so contacted the applicant in the capacity of a friend, requesting her assistance on account of a serious health condition that required medical attention and prevented him from looking after himself. When the applicant inquired about the possibility of his family's assistance, he expressed reluctance to burden them. Considering their past acquaintance and motivated purely by humanitarian concern, the applicant responded to his subsequent request and assisted him in obtaining the necessary medical treatment and care. Having ensured that he received the required assistance, the applicant left and returned to PG accommodation, resumed the status. But this is how the entire fact is, Milord. So I'm in Delhi. Obviously, of course, there is no denial, Milord, that there was a audio call, Milord. not the video call, my lord. And everything was informed to the deceased that from here in after today, I have parted my ways with the guy, and both of you live happily, my lord.
No, incident took place on
14, my lord.
14. On 14, you were there with the.
I was in Delhi. The boy was also in Delhi. For a
Okay,
medical.
The incident, an incident took place where?
Each other.
Itanagar.
Each other.
Okay,
No, my lord,
on the same day,
on the same day,
14.
14, my lord. And, my lord, just I got one order.
Hmm.
And then it publicly, the main accused in this case has already been granted bail after filing of this application yesterday
Where?
by session court.
Okay. Who granted anticipated bail.
So kindly protect me with usage time if my lord wants to be like.
Okay.
The fact is written.
Yes, sir.
Yes. My lord, my lord is
cost-
not bound by the order of the session court.
No, not
How-
mind, not
how-
No, no, that
my
is
lord-
true. That is true.
Yes, ma'am.
very true, my lord. Just, I got the info.
But
So,
did you apply there? No.
No, I have not applied because we were not aware, my lord. We filed yesterday.
Hmm.
So then, this morning yesterday, after filing, we came to know about this order yesterday. So we could not annex this. I'm sorry, my lord.
it's better they prepare there. Otherwise, my lord, I will make objection in this bill application, my lord, because my learned my senior colleague has narrated the story from their end.
Ah.
But since this is a privilege or pre-arrest bail, my lord.
Right.
So, my lord, the court has to ascertain whether there is a prima facie case against the present applicant or not. And to find out what exactly has happened, for that the case CD has to be perused.
Yes, yes.
But so far as the FIR is concerned, my lord, it's
Hmm.
very clear, my lord, her involvement, my lord. My lord will find in third para, my lord, there onward.
Hmm.
But later, I came to know that my deceased sister has forwarded her mobile number password to her so-and-so, and having unlocked her phone, I found a video clip which was sent to her boyfriend so-and-so, stating the reason of her suicide is reason for her suicide, my lord, is so-and-so, the present applicant. One is the present.
They are named.
Yes, absolutely, my lord. The name has been clearly disclosed. Now, and my lord, later on, my lord will find later, it is submitted that so-and-so has in relationship with my sister for years, and even the family member of had approved and acknowledged their relationship to me just few months back, and thus so-and-so relationship were acknowledged by the family member. Now, of late, it was found that Sri so-and-so has another girlfriend with whom he was harassing my sister. Now, it clearly corroborates with the statement of the learned senior colleague that they both were together in Delhi, my lord, through WhatsApp group call. As per record on 11th March 2026 at 12:07 p.m., Miss So-and-so, the present accused, my lord, initiated a group video call, and they had 28 minutes, 16 so argument, my lord. Hot 16-second hot argument, and again on 12:44 p.m., my lord, very precise, my lord, again had a video call on 14 March 2020 during the day happening, date of incident, my lord. 4:38 p.m. had two video calls. On 4:52 p.m. sent a photo of so-and-so that she has committing a suicide. On so-and-so sent a video to so-and-so showing that she is going to commit suicide.
Please pause
On
my.
so-and-so, let me complete, sir, please, then you come. On so-and-so initiated video, again, group video call. It is found that for the past few years, the deceased has been under severe mental stress and harassment caused by so-and-so boyfriend, one, my lord, the present accused, and so-and-so, due to continuous harassment and inducement by the accused, and the deceased become mentally disturbed and ultimately took extreme steps to commit suicide, my lord. This is well suffice. This will suffice because, my lord, so far as the abatement of suicide is concerned, my lord, the proximity matters, my lord. And this FIR clearly disclosed the proximity. Now, this court has to find out the story whichever has been narrated by the learned senior colleague, is in consonance with the finding of the investigation agency or not, or whether it's just a concocted one, my lord. And whether the CDR, basing on the CDR, everything, whether the prima facie case against the accused is made out or not. If made out, my lord, if prima facie case is made out, the offense punishment is up to 10 years. There is no any, my lord, ground for extending privilege of pre-arrest bail, my lord. If punishment was for 7 years, my lord, then situation would have been different. But punishment is for, my lord, 10 years. So the general, my lord, guideline will apply in this case as well, my lord. So after perusal of the CD only, my lord may consider their bail application.
Well, the learned additional PP was correct in one sense, but I will have to defer for one reason, Miller. Miller, kindly flip back to page 20, Miller. Page 20, Miller. Second last paragraph.
Yes.
Now, now of late it was found that so and so has another girlfriend with whom he was harassing my sister through WhatsApp group calls. As per records on 11 March 2026 at 12:07 p.m. Ms. So and so initiated a group video call and they had 28 minutes of argument, and again on 12:44 p.m. again had a group video call. Now, thereafter, can you see on 14 March. This is 11 March. This is a story of 11 March, Milord. And everything had happened on the 11 March. And on 14 March, how he committed suicide, where my role is not there at all, Milord. On 14 March 2026, during the day happening, Milord, this sentence. 4:30 p.m. had 2 video calls. 4:52 p.m. sent a photo to so and so that she is committing suicide. Not to me, Milord, to the boyfriend. On 5:04 p.m., so and so sent a video to so and so showing that she is going to commit suicide. Now 5:12 p.m. initiated a group video call, Milord. The boyfriend. Well, Milord, my role is very negligible. Therefore, Milord, I have to respectfully differ with the allotted additional PP. of
Anyway,
putting the
we'll call for the case diary then.
Milord, till then,
So-
kindly protect. It's a young boy, young girl, Milord, preparing for the UPSC, Milord. She was also trapped in a honey trap, Milord. That much I can say, Milord. Kindly protect her till then. Why to destroy her career, Milord? I'll cooperate, Milord. I have categorically made it, and I
Hard
don't have
Mr.
any
P.P.
criminal
Tara,
background.
Lani Council for the petition. Also hard Mr. Peto, Lani additional PP for the state staff. Huh? Apprehending or arrest in connection with the
Kindly listeners to come from Edinburgh.
Chimpu police station.
Come from Edinburgh.
What is it? Chimpu police station or Itanagar PS?
Chimpu,
It's Chimpu.
PS.
Chimpu
PS.
PS case number 18, 2026. Registered under section 108 and 3 within bracket 5 of the Bharatiya Nyaya Sanhita 2023. The accused petitioner filed this application under section 482 of Bharatiya Nagarik Suraksha Sanhita 2023 seeking pre-arrest bail. Stop.
Was settled over. No, he settled down. He was good.
The allegation against the accused is the allegation as per the FIR is that the main accused has another girlfriend, which is the present accused applicant, with whom the main accused was harassing the deceased through WhatsApp group calls. Stop. As per record, it is stated that as per records on 11 March at 12:07 p.m. the present accused applicant initiated group video call, and they had 28 minutes 16 second of argument, and again on 12:44 p.m. 44 p.m. again had a group video call, and that it was found that for past few years the deceased had been under severe mental stress and harassment caused by the main accused and the present accused applicant due to continuous harassment and inducement by the accused persons. The deceased, being mentally disturbed, ultimately took extreme step of committing suicide, and thereby the accused applicant along with the main accused has abetted the commission of suicide. Stop. The contention of the accused applicant is that she is innocent and hardly role to play, as she has left role to play, as considering that the main accused had another girlfriend, that is the deceased. She left on 11th. And thereafter, she had no idea. And okay, 11th. The above allegation and the allegations need to be examined, for which a case study is required to be called for. Accordingly, call for the case study of the Chimpu PS case number 18/2026, registered under section 108(3)(5) of the BNS 2023. Stop. In the meantime, as an interim, in the meantime, and then list the matter, when this matter to be listed?
No, I require at least 3 days time to appear.
List for listing of
No, just
What?
require 3 days time to appear.
Chimpu.
Then, but let me see.
at least 1 week then.
I have some difficulty because day after I'm filing our council nomination.
Then on 30,
27, 28.
30.
Time on 2nd April.
Second
April. I will be free by that time.
Second would be last, then on 6th straight away.
Okay, my lord.
Fine, my lord.
Okay. List this matter. On 6, on which date the landed additional PP shall produce the scanned copy of the case diary along with the status report.
Yes, ma'am.
Okay. Stop. In the meantime, in the event of the arrest of the accused applicant, she shall be released on interim anticipatory bail on execution of a bail bond of rupees 30,000 with one surety of like amount of bail. to the satisfaction of the arresting authority. Subject to the condition that the accused applicant shall, subject to the following condition. One, that the accused applicant shall cooperate and appear before the IO of the case as and when called for. Next, that the accused shall not directly or indirectly make any inducement, threat, or promise to any person acquainted with the fact of the case so as to dissuade him from disclosing such fact to the court or any police officer. That the accused applicant shall not leave the jurisdictional police station without informing the IO of the case.
Yes, madam.
Okay. Please, this matter, I think, again on 6th.
My only prayer will be, my lord, from my end, my lord, the objection may be recorded that I have objected the granting of the bail.
Okay. Then, in the above, on the above, in the above circumstances, the landed additional PP object granting pre-arrest bail.
Yes, ma'am.
Okay.
That will suffice.
Okay.
Obliged.
Please be obliged.
Item number 4.
May I please, Your Lordship? Your Lordship, this is the application under section 482 BNSS for granting pre-arrest bail. Your Lord, this is the fresh application after you are withdrawing the earlier one, Your Lordship. This liberty has been granted to file the fresh one. The earlier application was withdrawn on the ground that I have not complied with the abide by this notification issued by the Honorable Guwahati High Court, Your Lordship. Your Lordship, this is the application, Your Lordship, that
Pre-arrest bail.
pre-arrest bail, Your Lordship.
What is the complaint? What is the,
Your Lordship, no FIR has, no FIR is, no formal FIR is there, Your Lordship. Only GD, I have mentioned the GD number of Sejusa Police
yeah,
Station.
yes, you obtain instruction there.
Yes, there is an FIR which has been not registered, Your Lordship, preliminary inquiry perhaps, because if the GD, normally whenever a complaint comes and the eye of the police feels that the matter should be preliminary inquired first, so
If there is no FIR, then on
There
what
is no
basis you are filing?
Your Lordship, there is.
Have you been informed that there is a GD entry
yes,
or FIR lodged?
they have written the GD entry, mentioned the GD entry, Your Lordship.
Hmm?
They have mentioned.
GD number 05 of,
Where from you got this?
Your Honor,
Where
From
did you
the-
get this?
from the, Your Lordship, from the police station, Your Lordship. An FIR has not been
Where is under
furnished.
section? Under section?
No section has been mentioned, Your Lordship.
Have you been called by the police to appear?
Yes, Your
before the-
Lordship.
Where?
Your Lordship, on 12th of this month, Your Lord, in annexure number, call records, a screenshot has been, Your Lordship, annexed as annexure number 4, Your Lordship.
Hmm?
Annexure number 4 is the call record being made by the
Annex number 4 page.
page number, Your Lordship, annexure 4. Page number 23, Your Lordship. This is the screenshot of the call record.
You did not pick up also then?
Your Lordship, I have
No,
picked
you
up
have
and
to
called.
obtain,
I have
obtain
talked with,
instruction. What is the allegation? Is there a register? Okay.
Yes,
Okay. Mr. Mr. Gara,
Kegar.
Gara, land counsel for the petitioner.
I have been, Your Lordship, threatened to.
No,
raise
no,
the-
no. How do you know?
I
You
was
did not
called
receive
by
the
the
phone call also.
OC.
There is, it's only a missed call. You did not receive also. How do you know that this belongs to OC or IO? No, that will be.
23, Your Lordship,
blind.
23, page number 23.
It will be difficult. 23 I've seen, there's a missed call only.
I have talked, received,
Where?
Well, yes, I have picked up your lordship. I pick up the call also, your lordship. He,
You could have asked, what
he,
is the complaint and what is the-
the OC of the concerned police station, he,
And your lordship has rightly pointed out, if there is no FIR registered, there is no
then
apprehension and this is
wha-
not maintainable per se.
what he says? You knew it. Anyway, this is an application file under section 482 of BNS Bharatiya Nagrik Suraksha Sanhita 2023, seeking grant of pre-arrest bail. In connection with FIR, undisclosed FIR a GD. No, this need to be,
GD number
no, this
05.
is not maintainable.
Yes.
Your lordship,
Not
there is serious
maintainable.
apprehension is there, your lordship.
What apprehension? What apprehension in what case?
On your lordship, in page number, your
Is
lordship,
non-bailable offense?
yes, your lordship.
Okay, what is the offense
Your
then?
lordship,
Now you tell.
your lordship, my mother, this informant is my mother, your lordship. My mother has gifted me
Okay.
one
No,
land
okay.
in the year 2024. This page number, your lordship, 24. Is the annexure.
No, you obtain instructions,
Yes,
right? Better, huh?
On Monday,
Uh,
your lordship.
Okay, GD number GD number. FIR at GD number 005/26 dated 3/3/2026.
Your lordship, now I am now admitted at some life-threatening disease, your lord, one. This is a very rare disease that I have.
This is liable to be dismissed.
Absolutely.
It's not maintainable only. But then if you want,
Yes, if they themselves are saying that it's in the GD entry form, your lordship. In GD entry form, normally when there is a requirement of preliminary inquiry, GD entry is made and during without registration of FIR, there cannot be any kind of arrest. And if the arrest cannot be
this
made,
shows that you are not required to be arrested.
yes. And if there is no provision for arrest during the GD entry, there is no apprehension, obviously.
You obtain the FIR and then come only when registered. I'm dismissing it.
Your lordship,
this-
FIR,
this will be
your
too much.
lordship,
Now, how,
FIR is your lordship, not the
it-
conditional
see,
president.
it would amount to giving a bail in no offense.
Absolutely not.
It's a blank, it will be a blanket protection of the accused,
Yes.
and you are not ready to disclose. We do not know it's 302 or it's
Any kind
just
of
a,
provision.
just bailable. We do not know. There it will be difficult.
Your lordship, may I please, your lordship?
No, no. So
You know, in the year 2024, one land was gifted to me by my mother.
And we are not aware if this is the
We
reason.
do not
for
know.
any kind of.
And that I have gifted, father gifted this land to my sister. On that ground, my mother is of doubt that I might have sold this land and did not pay her, not pay the consideration amount. On that ground, cheating case might have been.
okay, I'm giving you opportunity, huh? Just obtain instruction. If nothing, then we'll dismiss on Monday. Okay,
Absolutely.
Miss Ginny, Lana additional PP, press, submits that she need time, she need to obtain instruction in this regard. And press for listing this matter again on Monday. Prayer allowed. This is again on Monday, on which date? Miss Ginny.
May it be on your lordship, Tuesday?
Tuesday, I'm not available, your lordship. I'll be on leave from
Okay.
14 days.
On Monday, huh? On which date Miss Jenny Landa Edison PP shall produce the apprised, or produce the case diary.
No, your lordship, take instruction of
Okay,
the-
okay,
any FIR.
Okay, apprise the instructions. Okay,
Dep-
received by her.
Obliged.
Item number 5,
May I please, Lordship? Yes. Also, this is a joint application filed under 528 by the informant and the LAGC for the person of FIR dated 0903 of 2025 arising out of Young's case and the charge sheet number 01 of 2025. Okay. We need to call for the record.
I'll just apprise this honorable court, your
Hmm.
lordship, and same similarly situated issue. There was a order passed by in a very recent case.
Coordinate bench and
There was an order passed by Justice A.M. Kalita, your lordship. Though the courts on many occasions had allowed such kind of quashment wherein the deceased parents as well as the accused had made a settlement, your lordship.
Hmm.
However, it's a very recent pronouncement of judgment was done on 11/3/2026. Your lordship would like to peruse this judgment, your lordship.
Hmm.
If I may take your lordship to paragraph 21, your lordship. It starts with paragraph 19, your lordship, at page number 14.
Hmm.
I'll just read, your lordship. Coming back to the facts of the instance case, in the instant case, the victim died because of rash and negligent driving by the petitioner numbers 1 and 2 and subsequently due to monetary consideration as compensation. The helpless wife and family members of the victim had agreed to compromise with the petitioners number 1 and 2 and to settle the entire dispute in a private agreement. From the aforesaid case laws that have been discussed, one of the most important aspect which emerges that in cases of compromise, a compromise is basically with the victim and the accused offender. Therefore, the principle is basically to effect that the victim does not have any grievance against the accused offender. But in a case of death resulted from rash and negligent driving, the victim is no longer there to say anything about the grievance or non-grievance. Therefore, the compromise between the informant or the family members of the victim and the accused offender cannot be said to be a compromise on the basis of the foundational principle that has evolved by various judicial pronouncements. Another important fact which needs to be considered is the cascading effect of rash and negligent driving in the public at large. It is also observed that in many of the cases of rash and negligent driving, the cases have been compromised by settlement by paying money as compensation before an FIR is lodged. By this type of compromise, what actually seems to have been done is that certain rich people are settling those cases by paying certain amounts to the poor victim's family. By doing such acts, that what actually is being done is that the rich people are buying their criminal elements from the poor victim, and the criminal jurisprudence in India is not to be so, as the criminal justice system in India is based on the concept of state versus the accused and not between the private individual. So even in this case, your lordship, I was the prosecutor while dealing the same case, your lordship. Though I have, if your lordship come to paragraph, because I would like to also show my submission, your lordship, at page number 5.
Now, what is the conclusion here in this case?
The conclusion made is in that in this case is that if your lordship come to paragraph 21, your lordship. Page number 21.
Yes.
In view of the aforesaid discussion, this court is of the considered view that in the instant case in hand, the plenary power under section 528 of the BNSS cannot be exercised to quash the criminal proceedings number so and so arising out of Itanagar so and so, dated so and so, registered under section so and so, on the basis of the aforesaid two mutual settlement agreement dated so and so. This court also has tended to add that the case of Ojingdaran was passed by the same honorable judge, your lordship. Cited by the learned counsel for the petitioner cannot be said to be binding on this court, as several judicial pronouncement of this honorable court, Supreme Court, were not cited before the coordinate bench while the matter was heard, your lordship. So according to this order, your lordship, in a case of death due to negligent, rash and
It's a
negligent,
that case.
then the court opined that normally when there is a mutual settlement, it's always between the accused and the victim. Now, when
Let us see the record.
yes, what I'm trying to say is that because I leave it to your lordships,
Yes, but we are
wisdom,
not
your lordship.
disposing. Now,
Yes.
but then let us see the record if there was some intention on some kind of play that they have made a mistake, but then wanted to compensate only.
There is otherwise,
Mm.
Your Lordship.
Mm.
Your Lordship may call for the record in.
Okay.
I'm on two ground. One is on settlement, other is on merit.
On merit also?
Yes. Lordship. On merit.
Let us-
Can I take it,
No, just, we'll call for the record. We'll see the record. Okay. It's still under investigation only.
it's on evidence. So,
Evidence stage. See, let us see then.
okay, my friend.
How many evidence, witness?
There is, 4 evidence. One is informant and two is two.
Now, if it was to be entered into an agreement, why you had to wait then? You have entered into agreement only when the material came against you, isn't it? Anyway, let us see the record, okay? The hard, Mr.
Lordship, I have a prayer.
M. At the Learned Counsel for the petitioner. Also heard Ms. F. Learned petition PP for the state staff. Joint petition,
Yes, joint petition
Okay.
as well as on merit.
this application under section 528 of the Bharatiya Nagarik Suraksha Sanhita 2023 has been filed jointly by the,
Normally. Normally,
who is the accused here?
accuse.
Petitioner number 2.
By the, okay, by the petitioner, the petitioners. Who? The petitioner number 1,
One
who
is the informant.
is the accused, and the petitioner number 2, who is the informant. In,
No, Lordship. One is the informant and 2 is the alleged accused.
okay, petitioner 1, who is the informant, and the petitioner number 2, who is the accused. In which case? GR case number 02/2025 arising out of Jang Police Station case number 01/2025 under section 106 within bracket 1, 125 and 281 of the Bharatiya Nyaya Sanhita 2023. Staff, issue notice, call for the scanned copy of the trial court record.
Lordship, I have a prayer.
Staff, so how long it will take? List this matter after 2 weeks?
2 weeks, Your Lordship.
Okay, after 2 weeks. Okay,
Lordship, in the meantime, is proceeding.
let us see. We'll consider your interim prayer after the record is received. Okay. Now she is raising objection. In that case, the stay may not be proper at this stage. Okay.
Depute.
Item number 6.
This is to be come after 2 weeks only.
Yes, this was supposed to be, I think there is a.
No. There is some direction from the Supreme Court. That is why I think.
Yes.
So then what we'll do, you are also not ready.
No, Your Lordship.
We'll fix the date then in that case.
Yes, Your Lordship.
Okay, when do
On
the
24th of.
matter has
24th?
been directed to be listed after 2 weeks. However, the registry has placed this matter in compliance of the direction of the Honorable Supreme Court in Sunni Chauhan versus State of Haryana. Stop, huh? The learned the additional PP is not ready with the trial court record is still awaited. Okay?
Yes, Your Lordship.
In view of the above, this matter again on
9th of April, Your Lordship.
9 April. Okay.
Depute.
Your Lordship, 9 is too long.
No, that comes after 2 weeks.
No. Is it?
Yes.
So we can prepone as per the direction because they want that the bail application should be expedited.
Yes, but then
So that
uh,
in then
then-
in that case, we can fix it on 7.
70, you know.
Okay. Hmm.
Item number 7,
Deeply applied.
Mayor Lordship.
Yes,
Lordship, I appear on both items 7 and 8. The
this is also, I
7 and
think this is also similar, no?
The teacher was called for lawsuit.
When do we fix it then?
Lordship, I have to inform this court one fact that on 5th of this March, the CC was conducted. And in that CC, the accused person was discharged. Because,
Already discharged.
yeah, he has been discharged.
Then this has become infrastructure.
Yes, Your Honor.
Oh.
Yes, he has been discharged. This is the,
Hmm.
And you have to withdraw this.
Yes. Hmm. Then, Mr. Okay, just
Keep
this
going.
is item 7,
7 and 8.
7 and 8.
Yes,
Okay,
discharged.
okay, Mr. Payang, huh? Land Council appearing on behalf of Mr. Tony Patin, Land Council for a petitioner submits that on
On 5th of March.
5th of March. On 5 March 2026. By an order dated 5 March 2026.
However,
Uh,
Lordship, the accused person is still in custody, Lordship. That
That
is why.
if he has been discharged, then how he can be in the under custody?
The allegation is that there are couple of more cases against him.
Okay,
That is-
then in
that
the
is-
some other case only.
Yes.
Okay.
But
The
Our contention here is
the
that
accused during the hearing of the during hearing of the hearing on question of charges has already been discharged, and therefore this bail application has become infructuous stuff. In view of the above, the Land Council praise for allowing him to withdraw this bail application on becoming infructuous. Stop. The prayer is allowed. This bail application stands dismissed on becoming infructuous. Okay, both 7 and 8.
7, 8 lawsuit.
Hmm.
Much obliged.
item number 10,
Yes.
Lordship, this is wrongfully to the list that it is, Lordship, already, Lordship, date was fixed on 21/4 lawsuit.
21, it's already
Yes,
fixed.
Lordship. Yes,
Okay.
Lordship.
Both the Land Council, sorry,
Lordship,
Mr. G. Pukon, Land Council for the petitioner, and Ms. L. Hage, Land Additional PP are present. Since the matter is already fixed on 21, let this matter be placed on 21. Okay,
no, 9th April, Lordship.
on 9th April.
9th
Okay,
April.
okay, then,
Because
Okay.
when I have a CC.
okay.
Consideration.
Present, Mr. G. Pukon, Land Council for the petitioner, praised for listing this matter on 9th April.
Yes.
Okay, instead of 21. Okay. Instead of 21 for 2026, prayer allowed, listed accordingly on 9 April. Okay.
Obliged,
Obliged.
Lordship.
item number 11,
Your Lordship, the service has been completed in this matter. However, we have not received the updated CDA, Lordship.
Okay, Miss Jean, P. Jeannie, Learned Additional PP, submits that she has not received the updated case CD. Therefore, prays for some more time. Prayer allowed. List this matter again on
Let it be on 2, Lordship.
2.
2 April.
2.
2 April, Lordship.
2 April, okay, 2nd April, on which date the Learned Additional PP shall produce the updated case diary.
Lordship, regarding service may be reflected in the order, completion of respondents number 2.
Okay, service, who appears for the respondent?
Non-FER, Lordship, but it was on last occasion.
The service recently been completed, Your Lordship.
Okay,
Directed through the OCPS.
okay, then, in the above. Where do we find?
The pink mark, Your Lordship.
Yes,
I think it's on
okay,
the,
then,
in the third page of the pink mark.
okay, then in between, huh? After parties, what Mr. Ingo, Lana Council for the petitioner and Ms. the Lana additional PP are present, staff. The service upon the
Respondent number two.
respondent number 2. Has returned. Oh, his signature is there.
It's, there is a receipt memo, Your Lordship. I think it's on the third page.
Hmm?
Third page.
Okay, okay. Okay. Return up after coding service upon the respondent number 2. In view of the above, the service upon the respondent number 2 is treated as complete. However, none appears on behalf of the respondent number 2. Stop. Then that submission, Miss submitted that case. Have you recorded? Okay. No.
Deep.
Matter number 12.
May it please your lordship.
Yeah.
Lordship has examined this case on previous occasions, my lord. Only the thing is that, my lord, the order of taking cognizance was supposed to be brought on record. It has been brought on record by filing an affidavit, my lord. My lord, the order of taking cognizance, my lord, the matter relates to, my lord, non-payment of money by the petitioner to the complainant, my lord. That remains. That is the case, my lord.
Just non-payment of
Non-payment of money, my lord, taken on the basis of an agreement, my lord.
what is it? IA is for what?
IA is for, my lord, the IA 526 is for producing the charge sheet, my lord. And subsequently, my lord, an
The
affidavit has
IA
been filed.
IA is 05.
05 is for, my lord, for producing the charge sheet laid in the case, my lord. Because, my lord, the initially, my lord, criminal petition was filed for quashing the FIR. Since there was no stay, my lord, the investigations proceeded on, my lord. Then subsequently, the charge sheet was laid upon. Then this charge sheet was brought before the honorable court by filing this IA, my lord. Again, my lord, after laying down the charge sheet, the GR case had arisen out, my lord. Then cognizance was taken, my lord. That order also is brought on record, my lord, by filing the affidavit, my lord. Last time. Cognizance taken.
Whether the respondent appear,
Their name has been shown, my lord.
Hmm?
Their name has been shown.
you are for respondent,
I'm for respondent.
private respondent.
Yes.
Okay, have you received the copy of the petition?
No.
You serve copy then? Okay, hard, Mr. We call it a Thane council for the petition.
Lordship, I actually served a copy, but they were the absent respondent. They was absent on that day. I served,
Whom did,
but they didn't,
whom did you serve? If they were absent,
no one was there,
then whom did you serve copy?
but hen only. I served
Then
the
to whom?
respondent, to the private respondent.
You said that he was absent.
There was not there. Actually, I went to their chamber, Lordship, to serve the copy, but none was present.
But anyway, my lord, the matter relates to, my lord, non-payment of
Okay,
money, my
okay.
lord.
Anyway.
Lordship has
let
already
him-
examined this case, my lord, on
Uh,
previous occasions, my
okay.
lord.
Let be Lordship fixed for the
Okay,
hearing,
admission
admission hearing, which is order stage today.
Land council for the petitioner. Also had Miss El Hage, land additional AG, additional PP for the state on behalf, for the state respondent number 1 and Mr. Hiram. Land council appearing on behalf of the private respondent number 2, who submits that he is yet to receive a copy of the petition. Staff, the council for the petitioner shall furnish a copy of the petition to the land council appearing on behalf of the private respondent within 3 days from today.
During the course of the day, we'll file.
During
During
the course of the day, staff, Okay, list is matter again after 2 weeks.
Lordship, till then, my lord, stay may be granted on the proceeding, because, my lord, because since there is no stay, the case has been developed, my lord.
Hmm.
Charge sheet has been filed, then cognizance taken, my lord. Now the case is fixed for CC. So till then, my lord, since the case is decided, my lord, because
We'll
this is,
take- we'll-
otherwise this is.
We'll
become
consider on the next date, the interim
lord,
perhaps
my
will
lord, this-
consider on the next date of listing. Okay.
My lord, next there will be the hearing date, my lord.
Okay. Huh?
That will be finally decided, my lord, till then, my lord, at least,
No, no.
till returnable date at least, my lord.
Okay.
Date may be fixed, or date may be fixed, my lord, for hearing, my lord. Fixed.
What is the allegation against the accused?
Allegation is nothing, my lord. Some money has been taken by the
You don't
petitioner.
worry then in that case, don't worry. Charge also will not be framed. You take part in the framing
My
of
lord,
charge and
my lord, I think
let
that
us
is
hope that
part,
you
my
are
lord.
discharged.
If
Let us hope
lordship-
that you are discharged at the time of framing of charge.
If lordship is
Hmm.
satisfied, lordship, if lordship is satisfied that the,
You satisfy the trial court first. That will be better. You will be happier
my lord,
also.
the pendency of
Hmm.
the
Okay.
proceeding, my lord, perhaps the learned trial court would not be pleased
No,
to
no,
hear
no,
the
no, no,
charge
no.
framing, my
Let
lord.
the charge be framed. At the time of framing of charge, you fight there,
Yes,
place your case, and then
I-
pray for discharge.
I agree,
Then
my lord.
we
but-
hope
but
that in that case, this also will be infrastructure.
That would be, of course, my lord, we hope so, my
Okay.
lord.
Okay.